Welcome back. An important development clearly on the taxation front for the overall corporate world, and something that brings comfort clearly to Shell. There is a development that the Bombay High Court has ruled in favor of the Indian subsidiary of Royal Dutch Shell, and that High Court order, which has come just a short while ago, sending out a huge positive signal, because remember, this case has been in the domain for a very long time, and IT department had in fact made two transfer pricing adjustments in this particular case. In fact, Shell India had issued 870 million shares to an overseas group company in March 2009. The tax department had claimed that the shares were undervalued and had said that the value of the shares should have been much higher. The tax department then added the difference to the taxable income of Shell India, but now relief coming their way with the Bombay High Court ruling in favor of Shell India. We joined now on the phone line by Mukesh Bhatani, well-known tax expert and chairman of BMR Advisors. Mr. Bhatani, good to have you here on the show. Your first thoughts on this judgment going Shell's way?
Well, I think it's a very positive outcome. Essentially, the Bombay High Court today morning held that on principles it has to follow the decision laid down in the case of Vodafone and look at only those issues that are very specific to Shell. Though we were arguing that the principles are identical and apply in the context of Shell, the tax department chose to distinguish Shell's case from Vodafone and brought out distinguishing features. To that, the Bombay High Court said that despite those distinguishing features, it does not alter the principles, and the principle being that if shares are issued, there is no case of any income arising from an international transaction, and hence the transaction is not exigible for transfer pricing provisions. So the question of carrying out an adjustment does not arise.
All right, we've had a similar case with regard to Vodafone also in terms of transfer pricing. Share with us the overall sentiment and how that impacts this, because, you know, whenever we talk about attracting foreign investment, we always talk about the tax uncertainty. The transfer pricing cases particularly have been making headlines. Share with us what this development means for the overall sentiment with regard to India.
I think there are two aspects which are very unique to this development. Number one is that there is an independent judiciary that's there to look into the actions of the executive. And if the judiciary feels that it needs to correct the actions or inactions of the executive, then it will intervene and do so. That's the first principle. The second important aspect is that in this case, court chose to invoke its writ right. Remember that Shell and Vodafone had invoked the writ jurisdiction and did not follow the ordinary administrative process, which can be a time-consuming process. And the court to intervene in a writ jurisdiction under extraordinary circumstances is the other important principle that emerges, because ordinarily under the law, if there is an administrative remedy that's available, then the courts do not intervene in this matter. However, in the case of Vodafone and Shell, the court decided to do so because it felt that the tax department was trying to bring something within the realm of tax which actually could not have been given the reading of the law and the interpretation of the statute.
Okay, Mr. Bhatani, share with us why this particular judgment is now important in overall understanding how transfer pricing will work in India, because clearly funding a subsidiary by issuing shares is a very common practice among multinationals. We've seen that happen. They typically view it as a capital transaction, not as something which falls under the transfer pricing net. Now, can we say that this particular judgment now rests the case, or can we see similar disputes now arising with the IT department making similar claims in the future? Also, have you seen a perceptible difference in the working of the IT department, especially with the new administration in place?
Well, I think two aspects. Number one, yes, as you correctly pointed out, that capital account transactions are not exigible to tax. And in this case, the tax department tried to bring a capital account transaction to tax. Given the reading of the transfer pricing law, there was never any doubt insofar as share issuance as a transaction is concerned. However, this judgment puts to rest the controversy, and I'm sure that it will benefit other multinationals who are issuing shares to their overseas subsidiaries who are otherwise in a related party situation. To your other point, I think insofar as the tax administration is concerned, yes, it is true that in the last few years, as a result of actions through the legislative process and the administrative process, multinationals have been very jittery about how tax laws are interpreted in India. So I think this judgment, in a way, will further help enhance the confidence of the taxpayers. I can't say whether this is all reflective of the changes in the administration, because the administration is the parliament and the executive, and the judiciary was always there, which has always been independent. But yes, under the new regime, this is certainly a welcome decision.
Mukesh Bhatani, Chairman, BMR Advisors, they're talking to us about the development of the transfer pricing case going in favor of Shell India with regard to the kind of dispute they had been facing. The Bombay High Court now finally ruling in favor of Shell India. Clearly a relief coming there for the large energy giant. With that, it's a wrap here from me on this show, but plenty more continues on the other side of a quick break.